We'll give it a minute and then we can begin. So we now have Chris as well. I think we could begin now. Okay, so tonight we're talking about capacity to contract, which is a crucial topic in contract law, mainly because it often happens that you have people who don't really have the capacity to contract actually enter into contract. So this could be teenagers, they could be buying cars, buying jewelry, or buying some appliances, and you begin to wonder if the contract they enter into is going to be valid or will be voidable. So that's an area of law we're examining in contract law. And we also wish to examine those who may have a diminished capacity in terms of having perhaps a mental disorder that actually diminishes their ability to enter into contract. So we're looking at capacity to contract, mainly from the viewpoint of those who are considered infants, and these are minors, in other words, those who are whose age would be 18 years and below. And so for tonight, after studying this topic, you should be able to demonstrate a knowledge of factors affecting capacity, particularly as a result of age, mental capacity, as well as intoxication. And then we will try to examine how contracts are dealt with if they are entered into by a person without capacity. And in a sense, we need to examine the interaction between common law principles as well as statutory law. In other words, a lot of states have actually legislated in this area, and they can have some applicability in terms of determining what the remedies might be to somebody who contracted with a minor, for example, or somebody with a diminished mental capacity, and what the rights might be of those with a diminished mental capacity, at least from the viewpoint of law. And so before we begin by addressing the tutorial questions, would anyone wish to raise a point or any questions that you might have that you may wish to raise at this time before we proceed? So we could begin. This is going to be an interesting case, and I'd say this is quite a complicated subject. It's a complicated topic when it comes to infants. It appears simple, but actually it is not. And I'd like to say in advance that when we have the online quiz on Friday, a lot of the questions are going to be based on this topic on infants and those who may have a diminished capacity to contract. So therefore, it's a good thing that you're actually here, because then you're in a position to explore in greater detail this specific topic. So let's begin by getting one of you, to read the tutorial question for us. Can I get a volunteer? Peter, Chris, Heidi. I think Sophie might have a problem with her microphone. So perhaps Sophie, Peter, Chris, or Heidi, do you mind reading the tutorial question for us? I don't want to have to read the question. Oh, Chris has no mic. Peter, your mic was working. So perhaps, we could listen into your voice again, your wonderful voice, and perhaps you could read the tutorial question for us. Peter. Or has Peter just frozen? What happened to Peter? Okay, he disappeared. So I think he had a problem there. Peter has disappeared. He dropped out. So he might have had a technical problem because his screen froze for a moment. Heidi, do you mind reading the tutorial question for us?
Sure.
Huh?
Sure.
Okay, good. Thank you.
Glennis, an expert seamstress, owns a fashion store in the city specializing in evening dresses. She's in the middle of the formal season and has a rush of orders from young women who have nearly finished high school and who are planning for their high school formal. One Wednesday afternoon, two clients come into the store at the same time. Nomaya is a typical formal dress shopper, aged about 17, and very excited about her high school formal. Unusually, she was shopping without her mother, but when Glennis asked about this, Nomaya told her mum is not really in the picture and dad knows nothing about dresses. Nomaya tried a range of dresses and eventually chose one which looked fantastic, which was probably somewhat shorter and more provocative than most of the young girls wore for this sort of occasion. Slight alterations were necessary, but this was not a problem. Nomaya paid cash on the spot for both the dresses and alterations and arranged to collect the dress 2 weeks later. The other client, Jenny, was a little older, perhaps in her mid-20s. She told Glennis she was a competitive ballroom dancer and needed a new competition dress. Glennis was a little uncertain as she knew ballroom dresses were specialized product, but Jenny tried on several dresses and seemed very happy with the one she picked up. Jenny paid a $200 deposit on a $2,000 dress, which had to be ordered from the United States, and Glennis agreed to let her know when the dress arrived. 2 weeks later, Nomaya arrived to collect her dress, but she was accompanied by an older woman who turned out to be Nomaya's mother. The mother, it seemed, was very much in the picture, but the two had been arguing about Nomaya's choice of the fashion for some time. Nomaya's mother was very happy with the dress Nomaya had selected. She demanded a refund, and while Glennis objected, she pointed out Nomaya was a minor. Glennis stated that she would wish to consult with her lawyer, and Nomaya's mother felt unhappily. Shortly afterwards, Glennis received a phone call from Jenny. Jenny explained that she suffered from a depressive condition and she had been without medication when she had visited Glennis's store 2 weeks earlier. She stated that she would be unable to pay the $1,800 outstanding on the dress, and she did not wish to proceed on the contract. Glennis was very unhappy because she had already paid the supplier for the dress. Glennis had come to me for advice. Are either of the contracts enforceable? Why or why not?
Okay. So let's begin by looking at the contract that was entered into between Glenys and Niall. Let's look at that first. So in relation to the contract between Glenys and Niall, is the contract enforceable? And for us to answer the question, we're essentially trying to determine whether the contract is binding or not, whether it's void or voidable. What do you think? Oh, is that pronounced as Neve?
N-E-V-E, it's an Irish name.
Oh, okay. Something is wrong with the mic. So the way you, Peter, the way you pronounce that name there, because I'm actually using the tutorial problem that Anthony Marinac prepared. So that name is actually pronounced as, hold on, how come this isn't moving? So hold on. So Peter, that name is pronounced as Neve. Is that correct?
Just Neve, N-E-E-V, without the E on the end.
So you pronounce this as Neve.
Yeah.
Interesting. Okay, I didn't know that. Thanks. Okay, I was having a hard time trying to figure out how to pronounce the name. But it had been there, so I didn't bother changing it. Okay, so let's examine the contract between Neve and Glennis. Is there a problem with the contract? Is the contract binding? Would somebody care to provide an answer? Okay, so we've got an answer here from Sophie. Neve's contract is not enforceable even though he's a minor because, oh, is this a guy? Well, this has to be a girl, right? We're talking of a dress here. So Neve's contract is not enforceable because she's a minor. Hold on. So Sophie, wait, I'm trying to understand what Sophie's saying here. So Neve's contract is not enforceable even though she is a minor because she paid consideration. So, and yet you're saying it's binding. So which one is it, Sophie? And some are saying not enforceable, not binding. Would somebody care to explain his or her answer? Maybe Dominique. Why would you say that the contract is not enforceable? And because it's not binding. Why is that? It's not beneficial. Is that what we look at? Whether it actually benefits the minor? Is that the key question there? Would anyone care to take the floor in the meantime? What exactly is the rule when it comes to minors? So let's begin with a question. If one of the contracting parties is a minor, is there a presumption of the law concerning the contract? Does the law make a presumption as to whether or not the contract is valid or not? Okay, so a contract, having a problem now with my browser. Okay. So from Sophie, she is saying that a contract with a minor is voidable. Okay.
Can you hear me?
I could hear you.
So, just to elaborate a bit more on that, it's also too if it's necessary for them, like if it's a reasonable request for her to have that dress. So, because she's a minor, it's not really necessary for her to have that.
I see. So
that's what I was getting at.
Dominique, you were using the concept of necessary.
Yes.
Why are we using that description there? What has that got to do with the law on minors in relation to contract law?
I'm not really too sure. I could have a guess.
Yep, try.
I'm just trying to think. It goes by the individual circumstances of a person, because she's under the age. Oh, I don't know really where I'm going.
Okay, let's begin by your point about the. Hold on. Okay, I'm just going to transfer what Peter has said here, put it on the screen. Okay, let's begin by asking this question. Is it necessary, as far as contracts entered into by minors is concerned, is it necessary to determine whether the good that was purchased, for example, by a minor is a necessary or not. So I'm using the word a necessary. I didn't say necessary because I'm not using it as an adjective. I'm more using it as a noun because the word necessary has a legal meaning. So why is it important to distinguish between a good that is a necessary and a good that is not, as far as contracts entered into by minors is concerned? So if a contract is a necessary, what then? If a contract is not considered a necessary, what then? So in other words, when I say necessary here, it means, is it a necessity? What's the significance there? So that's the question I'm raising now. So if a good is so, and it, it leads us to that other question. What happens if a good is not, is the good not a necessary or a necessity? So what is the implication, for example, if a good is not a necessary or is not a necessity? What does it mean? What is the legal effect? So what if the good that was purchased by a minor is not a necessary or not a necessity? What then? Okay, so the implication is that it would be voidable. Okay. Okay, now we're talking here, Peter has raised the point about void and voidable. What is the distinction between the two? Can we just examine first the difference between a contract that is void and a contract that's voidable? Because Peter is saying that if it is not, then the contract could be void. So a contract that a minor enters into, regardless of whether or not we ask whether the good is actually a necessary or a necessity or not, is that kind of contract entered into by a minor considered void or voidable? And what is the distinction between the notions of void and voidable? Or are they the same? So there were two questions.
If there's a contract considered in play, then the minor has the choice of repudiating that contract or agreeing to the contract.
Okay. Would anyone wish to, thank you, Peter. Would anyone wish to provide another answer? So from Sophie, void is already done. Voidable is coming to distinguish. From Dominique, voidable you can still rectify. I'm not convinced that any of these answers so far is correct. What is the key distinction between void and voidable? Between a contract that is void and a contract that is voidable? I'm not convinced that any of the answers suggested so far is actually correct. What do you think? Okay, so let me just answer that. Okay, cannot take it further in law. Okay, Peter, so you're saying, Peter, that if a contract is void, you can take it further in law. What does it mean when you say it can't be taken further in law? when we speak of the notions of void and voidability, we're actually trying to determine whether the contract is valid or not. That's what we're saying, right? So we're saying that, you know, if we're saying that the contract is void, we're actually saying that the contract is not valid. So when we say that a contract is void, we're saying that the contract is not valid. It's invalid. And therefore, because it's invalid, it's not enforceable. Now, if a contract is voidable, what does it mean? So if a contract is voidable, on the other hand, it is valid until it is voided, or it is valid until it is annulled. So if a contract is voidable, as far as the law is concerned, it is valid, it is binding. So it will lead to, it has a legal effect, and parties continue to be bound under the contract, but because it is voidable, it can possibly be annulled or set aside or declared invalid. Okay, so a contract that is void means that it is invalid and cannot be the basis of any rights between the contracting parties. A contract, however, that is voidable means that it is valid until it is annulled or voided at the instance of one or both parties. So that's the starting point. Now, the question is, a contract that is entered into by a minor, would that contract be void? Is it valid? Is it void? Or is it voidable? Okay, so that's the correct answer there. A contract that is entered into by a minor is voidable. At whose instance? Who can avoid a contract entered into by a minor? Can either party, so assuming there's a contract between a minor and another one who's not, can either party void the contract or avoid the contract or have the contract annulled? Let's just clarify that point first. So if a contract entered into between a minor and a non-minor, if there's a contract that's entered into between a minor and a non-minor, can either party avoid the contract or have the contract annulled? What's the answer there? Okay, so the answer is only the minor can have the contract voided, because that law seeks to protect the minor. A person who is not a minor, the other contracting party, does not have the right to seek the annulment of the contract or to seek to avoid the contract. That right belongs only to the minor. Now, so we've clarified so far the distinction between void and voidability. So a contract that is void means it's invalid from the very beginning. So there is no way that it can become valid because it is void from the beginning. A contract, however, that is voidable means that it is valid. So it can be the basis, therefore, of rights between the parties, but it can be avoided or sought to be annulled by one of the parties. In this case, it can be sought to be annulled by the minor, because the law seeks to protect the minor. The other party, however, does not have the power or the right to seek the voidability of the contract. That power rests only with, or that right rests only with the minor. Now, having said that, under what circumstances, so you have a contract that's entered into by a minor. Do you seek to distinguish whether or not the contract, whether the subject of the contract or the good, for example, is a necessity or not? Why is that distinction necessary? So in other words, the question is, if a good is a necessity, what is the effect? And if a good is not a necessity, what is the effect? So can we go to this now? So if a good is not a necessity, what is the effect? And if the good is a necessity, what is the effect? So, according to Sophie, if the good is a necessity, then it is valid. Is that correct? So in other words, the contract is valid and binding. Is it as simple as that? Okay, people seem to have a problem here with the microphone. Okay. So there's more to it than that. Now, so let's go through this because you seem to have a problem with the microphone. So if a good, we're talking general principles now, if a good is not a necessity, then it can be voidable at the instance of the minor. Now, if the good, however, is a necessity, then if it meets the criteria, then it can be then the contract will be considered valid and binding. It will not be voidable, but it will in fact be valid. So let's repeat. So as a basic principle of law, if a good is not a necessity, then the contract will be voidable. If the good, however, is a necessity, then it will be considered valid and binding. So it leads us to the question, let's assume, therefore, you have a situation where a good is claimed to be a necessity. What needs to be proven? What needs to be established in order to say that a good is actually a necessity? What is the two-tier test that Peter is alluding to here? What is the two-tier test?
I'll have a go.
Yes?
If it's adequate and reasonable, the price is reasonable.
Is it about the price? And you say adequate, what does adequacy mean? Is it a question of it being
Like
beneficial?
if they already like had a dress, or if they already had enough dresses.
Okay.
In that sense of adequate.
Okay, so, yep, so from Peter, it fits their station in life. So the proper phrase that has been used in jurisprudence, for example, in Nash versus Inman, the first question that needs to be asked is the good suitable to the condition in life? So when you say necessity, it's not equivalent to something that is crucial to survival. It's something that is suitable to the condition in life. So you might need one for the purpose of, having to go to work. You need a dress. You might need even a mobile phone. The question is that good suitable to the condition in life? That's what necessity means. And the courts have already ruled that as far as dresses are concerned or clothes are concerned, they can in fact be considered necessities. Okay, but that's only one part of the question. So when a minor purchases an item, the first question that needs to be asked is, in order to answer the question of whether or not the item or the good is a necessity, the question is that good suitable to the condition in life? So in other words, do you need it for clothing? Do you need it for shelter? Do you need it for work? And so on. So it's a broader concept than the notion of survival. But having said that, what then needs to be established? What's the second thing that needs to be established? So the second requirement is the question of whether or not it is suitable to the actual requirements of the minor at the time of the sale. So you might say that it is suitable to the condition in life, but you need to ask the question whether or not it's actually suitable to the actual requirements of the minor. So there is no question. You might say that clothes or a mobile phone or even shelter would be suitable to the condition in life because it is beneficial. It certainly helps a minor. But the other question that the law asks, and this becomes a question of fact, is whether or not that good or item is actually suitable to the actual requirements of the minor. So this specific minor, as far as this specific minor is concerned, the question is it suitable to his or her needs or his or her actual requirements? So suitability in terms of the condition in life, that's a question of law. So the judge can determine whether or not this particular item may be said to be suitable to the condition in life of most minors. But whether or not a particular good is actually suitable to the actual requirements of a specific minor, that is a question of fact, which requires evidence of whether or not a minor would actually need a specific good or not, based on the specific situation of a minor. So it can take into account the wealth or the economic condition of a minor. It can take into account his actual needs at the time, whether he needs it for work or he needs it for the purpose of studies and so on. So those are two distinct conditions. Okay, so having said that, going back therefore to the question of whether or not Neve can actually have the contract voided, we need to ask the question therefore, as far as that dress is concerned, as far as Neve is concerned, is that a necessity or not? Sophie says not. Why isn't that a necessity as far as Neve is concerned? Can somebody explain that? So as far as Neve is concerned, is the dress a necessity or not? Okay, so we know that the dress is for the purpose of having, a school event. Now, so because the dress was going to be used for the school formal, would that meet the first test, that the dress is suitable to the condition in life? Would that be a yes or no? No from Dominique. Why is that, Dominique? So if a minor purchases a dress because the minor wishes to use it in a formal event, that wouldn't be considered a necessity? Because you don't have to go to the formal. So let's just say that a minor wishes to buy a dress, and it's just an everyday dress. Would it mean that it can't be considered a necessity? Not this type of dress. Okay. Okay, so as far as the first criterion is concerned, because there's a two-tier test as established by the courts in Nash versus Inman, whether or not the dress is suitable to the condition in life, I think we can agree that it is suitable to the condition in life. In other words, a minor such as Neve, or any minor for that matter, is likely to require a dress. Now, whether or not the dress is necessary for a formal or it could be for everyday wear, is likely going to be less important. It can, however, be considered on the basis of the decision in Nash versus Inman that the courts are likely to acknowledge that a dress is suitable to the condition in life, because everybody needs a dress. I mean, not really everybody, but women need dresses. And especially if it's going to be in the context of a desire on the part of Neve to wear it at a formal, then arguably it will be easier to establish that it will meet the first condition, or the first criterion of the two-tier test as established in Nash versus Inman. So as far as the first one is concerned, the answer is a yes. Now, in relation to the second question, however, suitable to the actual requirements of the minor at the time of the sale, what needs to be established here? Is this a question of fact or is it a question of law? Because the first one, we actually applied a presumption of law. So in other words, a judge can actually make a determination that by looking at this good or by looking at this item, he or she can assume that that item is suitable to the condition in life. So he will just say, yes, it meets the first criterion. But that second question of whether or not that item is actually suitable to the actual requirements of the minor at the time of the sale, is that a question of fact or is it a question of law? Because if it's a question of fact, what it means is you have to examine the specific circumstances of the minor, which means, therefore, that depending on the circumstances of different minors, the answer may be yes or no. Okay? So, Peter, therefore, would be correct that it is a question of fact. So, if it is a question of fact, how then do we establish that it is suitable to the actual requirements of Neve? What needs to be shown? Okay, good. So from Peter, she does not already have an abundance of formal dresses. So, if, as correctly pointed out by Peter, that Neve does not have an abundance of formal dresses, then it will be easy to show that Neve does require a formal dress. But if Neve already has many formal dresses, then it becomes difficult to establish or show that Neve actually needs this specific type of dress. Okay? So that's where it becomes a question of fact, depending on the circumstances. So if the situation of Neve is that she actually has an abundance of formal dresses, then in that case, this requirement would not have been met. So if Neve has an abundance of formal dresses, then it can be shown that as far as Neve is concerned, that dress would not be suitable to the actual requirements of Neve because she already has a lot of dresses. And that is exactly what happened in the case of Nash versus Inman, because the minor in that case purchased a number of expensive clothes, and it turned out that his father had already given him a number of clothes as well, so that there was really no need for that gentleman to be buying more clothes. But had the situation been different in the sense that the gentleman or the minor really had few clothes, and therefore he needed to purchase one or more clothes for school, for example, then in that case, the second requirement that the purchase of clothes would be suitable to the actual requirements of that minor would have been met. So in this case, therefore, in answer to the second question, it's all a question of fact. It now all depends on whether or not, looking at the background of Neve, she actually has an abundance of formal dresses or not. So that's one. Okay. So was that clear? Is that clear so far? Now, so we don't really know. At this point, we haven't really answered yet whether or not that contract is voidable or not. So if we assume that Neve actually does not have an abundance of formal dresses, then it can be argued that therefore that dress would be a necessity. On the other hand, so in that case, possibly the contract can be binding. On the other hand, if Neve has an abundance of formal dresses, then in that case, Neve can seek to void the contract. So you can see the distinction there. So if it is a necessity, because it meets the two criteria, then it will be difficult for Neve to seek to avoid the contract. On the other hand, if that dress is not a necessity, then she can seek to have the contract avoided. Are we clear so far? So as far as the answer is concerned, it depends really on whether or not Neve has an abundance of formal dresses or not. that will determine whether or not the contract is voidable or valid. Okay, clear so far? Now, let us assume, however, that as far as this contract is concerned, let's assume that it is not a necessity. So now we're assuming, because remember the question here is the contract enforceable? So let us assume that the contract between Neve and Glenys is voidable. What then? Voidable because the formal dress is not a necessity. What then? So I'm asking that next question now. Let us assume that the contract between Neve and Glenys is voidable because the formal is not a necessity. What happens then? So in other words, let us assume that the contract therefore will be voided. It becomes it's avoided. It's voided. What then? Will it mean that Neve can seek the return of her $200? Will it mean that Neve can ask for the return of the $200, and in addition, she can ask that she ends up having the dress? Meaning that she can keep the dress. So, in other words, there's the question of restitution. Can Neve ask for the return of the $200 deposit? Because I think that's the amount of money that she deposited. What is the answer there? What about the price? Does the price come into play? Good point. That's a good point. Okay, so Dominique has a very good question here. Does the price come into play? Very good question. Very good question. Does the price come into play? So we addressed that first point, as pointed out by Peter, that in relation to the second criterion of whether or not the good is suitable to the actual requirements of the minor, one of the questions we asked was whether or not she had an abundance of dresses. But this time, Dominique is asking the question, does price come into play? Yes or no? Let's answer that first. The answer has to be yes. So thank you for pointing that out, Dominique. It comes into play. So what does it mean? So when we say that price is actually relevant, in order to answer the question of the suitability of the good, what are we saying here? So the price of the good is a relevant question. So what are we saying when we say that? So if the price is reasonable, so what? If the price is unreasonable, so what? And what do we mean by reasonability here? Are we looking at the objective amount of the price? Like if a dress, for example, is sold for, was it sold for $2,000? Yeah, so the dress was for $2,000. Okay, so when we say that the price is reasonable, do we mean that it's reasonable in relation to other dresses of the same kind? Meaning, if you were to look for that kind of dress, other stores are selling it for that same price. So therefore, if most stores selling a similar item would be selling it for that price, would that mean then that the contract is valid? Or what do we mean by the price being reasonable? What is our basis in trying to determine or look at the reasonability of a price? Okay, good. So as pointed out by Chris, it's actually relates to the ability of the minor to afford them. So that is the correct answer there. As far as determining, whether or not a price is reasonable, it's not a question of the price being reasonable in relation to other stores selling the same item. The question is whether or not the minor can actually afford to pay it. So therefore, depending on the financial situation of a minor, depending on the economic status of a minor, if that minor comes from an affluent family, then that minor will be in a better position to afford a more expensive dress. But if a minor, on the other hand, comes from a less privileged economic background, then chances are the minor would be unable to afford it. So when we say, therefore, that it's suitable to the actual requirements of the minor, not only are we trying to determine whether or not that minor has an abundance of clothes, we're also trying to determine whether or not, as far as the ability of the minor to purchase that item, it can actually be said that the minor will be able to pay for that item. If the item, therefore, is well beyond the capacity of the minor to pay, then we can say that it is not a necessity. Because necessity means an item that is a necessity or a necessary to the minor must be an item that is suitable to the actual requirements of the minor. So was that clear enough? Would it go on to the parents' affordability? Yes, that will have to be a factor that will have to be considered. Because obviously, as far as the minor is concerned, although there are some minors who might be in a position to actually pay it, we do know the reason why they're minors is because they're likely to be living with their parents. So assuming that the minor on his or her own is not in a position to pay for it, and we make the assumption, therefore, that the parent is likely going to be the one who will cough up the amount involved, then therefore the parent's ability to pay will have to be considered as well. So what will be considered will be both the capacity of the minor and the capacity of the parent or the minor to pay for the good. So it's possible that the minor can't afford it, but if the parent can, then it would still be suitable to the actual requirements of the minor. So in the case, for example, of Nash versus Inman, what the court considered was not the ability of the minor to pay. It was actually the ability of the father to pay, because it was the father who was supplying or paying for the clothes of the minor. It might also happen that the parents cannot afford the good. But if the minor, on the other hand, is actually working and has income or has savings, if it can be shown that the good is something that the minor can afford because the minor has the money, even if the parents don't have enough money, that will not go against the validity of the contract or the good being a necessity. So we look at both situations there. Clear so far? Now, let us assume that the contract versus Neve and Glenys is voidable because the formal is not a necessity. We make that assumption. So we make the assumption that it is not a necessity because one, Neve may actually have a number of formal dresses already, so she doesn't need it. Or two, the dress seems to be well beyond the capacity of either Neve or her parent to pay for. So that's the reason why the dress will not be considered a necessity. The relevant question then is, can Neve ask for the return of the $200 deposit? That is the next question that we need to answer. So what's the answer there? Can Neve ask for the return of the $200 deposit? So is that an answer from Dominique? The answer is yes. Can I get the answers from the others? So assuming that the contract is actually voidable at the instance of Neve because the good is not a necessity, the question is, can Neve ask for the return of the $200 deposit? So from Peter, the answer of Peter is that it depends on whether there is full consideration occurred. Both sides gave something. And then from Dominique, she hasn't taken the dress. Are those two the same? That raised by Peter and that raised by Dominique. So because as far as Peter's answer is concerned, his only question is whether or not there has been full consideration. On the other hand, Dominique is raising the point that if Neve hasn't taken the dress, therefore, she can actually, it would seem, ask for the return of the deposit. Let's begin with that second point first, the one raised by Dominique. Assuming, well, we know for a fact that the dress hasn't yet been taken by Neve. Does it mean, therefore, that she can ask for the return of the $200 deposit? Or is that question actually relevant or not in law? Does possession matter? In law, does possession matter? From Dominique, if she had taken the dress, she could just return it for a refund. And what if Glenys refuses to accept the return of the dress? Would Glenys be in breach of her obligation? Why would that be the case? Which brings us to that question, is that really relevant? Okay, so we know it is voidable, but the question is, what is the legal effect of the voidability of a contract? The voidability of a contract on the basis that there's a contract between a minor and a non-minor. So we make the assumption that a contract is voidable. But the question is, what is the legal effect in terms of remedies? So assuming that the contract is voided, what happens next? Does it mean that there is a total restitution so that both parties try to return what each other has collected or gotten from the transaction? Is that what the rule is? So in other words, if a contract is voidable, then as pointed out, for example, by Dominique, Neve would have the right to actually seek a refund. And if she had taken the dress, she would actually have the power to return it and then ask for a refund. Is that the correct answer? Or, so in other words, is possession relevant or not, as far as the law is concerned? Or is the bigger question that which has been cited by Peter, which is, the question simply is whether or not there has been consideration. What is the answer there? Okay, because we're running out of time, let me just go through this quickly because it's 6:55, got a class at 7:15. So the answer is, the question about possession is actually irrelevant. The only question is whether or not there has been consideration or an exchange of bargains between the parties. So it's not even a question of full consideration. The question is, has there been consideration? Okay, now, so whether or not that question of possession, as I will explain later on, may have an effect as far as the Sale of Goods Act under Queensland law is concerned. The Sale of Goods Act of 1896 Queensland, that may have some relevance. But as far as the common law principles are concerned in relation to contracts, that is not important. What is important, however, is the question of consideration, because under the common law principles, if there has been consideration involved between the parties, then in that case, restitution is no longer possible. So if there has been consideration, in this case, there has been consideration because in the sense that there has been an exchange of value between the parties. Neve paid the money, and as a result of paying the money, she then had the dress altered. Okay. Dominic is making the point that taking the dress would have been the consideration. That's correct. She did not. That's correct. But the question is, just because Neve did not take the dress, does it mean that there was an absence of consideration? Under the facts, would there have been consideration as far as Neve was concerned? So under the fact, there was consideration on the part of Neve because she had the dress altered. Not only did she have the dress altered, she actually had the dress ordered from abroad. There is clearly consideration. There is clearly benefit to Neve, right? And because there has been consideration, the law is, it is no longer possible for Neve to ask for the return of the $200 deposit. So in that case, given the fact that there has been consideration, Neve would then be bound by the contract. So it's actually, what it means is Neve cannot ask for the return of the $200. Now the question is, assuming therefore that the contract can be voided because the dress is not a necessity, the second question is it possible for Glennis to ask for the payment of the balance of $1,800? So we now say, as a matter of law, that because there has been consideration, Neve can no longer ask for the return of the $200. That is settled, okay? That is the law. So Neve cannot ask for the return of the $200. The question is, on the other hand, can Glennis ask for the payment of the remaining balance of $1,800? So from Peter, no. How about the others? The answer is no. So the point is, if you avoid a contract, what it means is that as far as this contract is concerned, although Neve can no longer ask for the return of the $200, Neve, however, is no longer in a position, Glenys, on the other hand, is no longer in a position to ask for the payment of the balance of $1,800. So the repudiation by Neve of the contract, by having it avoided, has the effect of having the contract terminated so that she no longer has any legal liability under the contract. But as far as any payments that have already been made by Neve are concerned, she can't ask for that payment back. And the case for that is actually Norman Baker Proprietary Limited versus Baker, a case decided in 1978 by the full court of the Western Australian Supreme Court. So clear? So let's go through this answer quickly. Let's just review it by way of fact. So in relation to this first aspect, is the contract enforceable? The contract between Neve and Glenys, is it enforceable? So it all depends on whether or not we consider the contract to be valid or whether or not it is voidable. So under the facts, if the dress can be considered a necessity because it is suitable to the condition in life of a person. A person needs a dress. So it can potentially therefore be a necessity. And if it is a necessity, then in that case, it can be valid and binding. But for a good, like a dress, to be considered a necessity, the other requirement is that it must be suitable to the actual requirements of the minor at the time of the sale. That is a question of fact. And there are at least two things that one will have to consider. The first question that needs to be answered is whether or not Neve would already have sufficient dresses, sufficient formal dresses. If Neve has sufficient formal dresses, then that formal dress that she purchased from Glenys would not be considered a necessity. And if it is not considered a necessity, then she can seek to avoid the contract. Now, assuming that Neve has an abundance of dresses, assuming that Neve does not have an abundance of dresses, the second question that needs to be asked is Neve actually able to afford that formal dress because it was worth $2,000? That is, again, a question of fact, depending on the circumstances of Neve. So if Neve has a lot of savings, she comes from an affluent family, then it can be argued that it is not a necessity. Then it can be argued that it is a necessity because it is suitable to her actual requirements. So if it is a necessity, then the contract would be valid and binding, and it could not be avoided. On the other hand, if it could be shown that the formal dress is too expensive as far as Neve is concerned, either because she doesn't have enough savings, or both because she doesn't have enough savings and because her financial condition does not allow her to actually purchase an item that is that expensive, then it can be said that the formal dress would not be a necessity. So if the dress, therefore, is not a necessity, then she can have it avoided. So we're clear about that. Depends. So whether or not the contract is voidable or not depends on answering whether or not it is a necessity. The formal dress is a necessity in relation to Neve. So we've dealt with that first question. The second question, however, is this. Assuming that the contract between Neve and Glenys is voidable because the formal dress is not a necessity, the question is, what then are the rights of the parties? So in relation to the question of whether or not it is possible for Neve to ask for the return of the $200 deposit, the answer is no, because there has already been a consideration and exchange of benefits between the parties. Then the law, as provided in the case of Norman Baker Proprietary Limited versus Baker, is that when there is already a consideration, then the parties no longer have the right to seek a restitution of their respective benefits. So in this case, Glenys gets to keep the $200. Clear? The second question, however, is, would it be possible for Glenys to seek to make Neve pay for the balance of $1,800? The answer is no, because that is in fact the entire purpose of having a contract avoided. If a minor seeks to avoid a contract or repudiate a contract, the minor seeks to be freed from the legal effects of the contract that the minor had wrongly entered into. So while Neve cannot seek a return of the $200 deposit, Glenys, on the other hand, also does not have the power to compel Neve to pay the remaining balance. So clear enough? We just have a few more questions to answer that next question. So the second question related to, hold on, where are we now? Oops. Missing something here. So the second question related to the second question related to Jenny trying to avoid the contract, meaning, so Jenny this time, Jenny also, so another person called Jenny purchased a dress. She's not a minor, but she is suffering from a depressive condition. So she was unable to pay the balance of the outstanding amount of $1,800, and she did not wish to proceed on the contract. The question in this case, the second case, as far as Jenny is concerned, is the contract valid, or is it void, or is it voidable? What is the status of the contract? And we begin by making a general assumption. What is the presumption of the law as far as limited mental capacity is concerned, on the ground, for example, of a mental condition? Does the law make a presumption in that regard? So as far as minors are concerned, the law makes the presumption that a contract that is entered into by a minor is voidable. Okay, so as far as the law is concerned, a contract entered into by a minor can be presumed to be voidable. The question is, as far as a contract entered into by a person who lacks mental capacity, is there a presumption of the law that the contract is also voidable at the instance of the person with limited mental capacity? So the answer is, I haven't seen the answer. Okay. So what is the yes there? Is there a presumption as well of the voidability of a contract? Let me repeat. Does the law make a presumption that a contract entered into by a person with limited mental capacity, for example, because of a mental condition, does the law make the assumption that the contract is voidable? Okay, so there is an answer here of voidability. The actual answer is the law does not make that presumption. So as far as the law is concerned, a contract that is entered into by a person of limited mental capacity is actually deemed valid. the law does not make a presumption of voidability, unlike the presumption that the law makes in relation to contracts entered into between minors and a non-minor. Okay? So there is no presumption of voidability. In fact, the contract, as far as the law is concerned, the law considers the contract to be valid. However, even if the contract is presumed to be valid, the person of limited mental capacity can seek to avoid it under certain conditions. What are those conditions that must be met before a contract can be voided? Okay, so from Chris, did she have the capability of understanding the contract? And secondly, was she aware of the conditions of the contract? Okay, is that correct? Is that complete? Are those two different things, or are they one and the same? So the capability of understanding the contract, isn't that the same as having an awareness of the conditions of the contract? Conditions or nature of the contract, would they be the same? There. So as far as Dominic and Peter are saying, the other question is, did the other party know of the condition, or was the other person aware of the mental capacity? So the two questions that need to be answered. So this is the first one. The person who alleges that he or she suffers from a limited mental capacity will need to show that that person is actually incapable of understanding the nature of the contract. That's one. So if it can be shown that the person was actually in a position to understand the nature of the contract, notwithstanding the limited mental capacity, the contract will be valid. So it is only when a person with limited mental capacity can show that because of the limited mental capacity, he or she is unable to understand the nature of the contract, can the contract potentially be declared voidable or void. Clear so far on that point? Now, therefore, as far as the notion of having a depression, you begin to wonder whether or not depression will actually lead to a person not having the ability to consider the effects of the nature of the contract. So that's the first question there. Now, assuming that a person actually is unable to understand the nature of a contract because of the mental condition, is that sufficient? Is that sufficient to avoid a contract? The answer is no. There is a second hurdle that has to be met, and that is whether or not the other person with whom the person of limited mental capacity contracted with was actually aware that the person had diminished mental capacity. Because if, as in this case, Glenys was unaware that Jenny had limited mental capacity, it would then be difficult for Jenny to ask that the contract be avoided. So there are two requirements there. First, it has to be shown that the person of limited mental capacity was, at the time of contracting with the other party, actually incapable of understanding the nature of the contract. That's one. But assuming that were true, assuming that the person of limited mental capacity was unable to understand the legal effects or the conditions of entering into the contract, the second question that needs to be asked is, was the other contracting party aware of the limited mental capacity? Because if the other party was unaware of the diminished mental capacity, the contract would still be valid, even if it could be shown that the other contracting party was of diminished mental capacity as to make that person incapable of understanding the legal effect of the contract. So those two tests have to be answered in the affirmative. Clear? So going to the question here, is it possible for Jenny, for example, to annul or avoid the contract? The answer is no. Because one, it is difficult to demonstrate. It will be difficult to demonstrate that at the time that Jenny purchased the dress from Glenys, that Jenny was actually incapable of understanding the nature of the contract. Just because she had a depressive condition at the time, it's unlikely for her to be able to say that she was unable to understand the legal effect of the contract. Secondly, it is unlikely for Glenys to have known about, assuming that Jenny in fact had a diminished mental capacity, it would be difficult to demonstrate that Jenny would have known of such a diminished mental capacity. So if therefore it can be shown, as it will likely be shown, that Jenny would have been unaware of the diminished mental capacity on the part of Jenny, then in that case the contract will be valid and cannot be avoided. Clear? Any questions? Because I've got a class in 2 minutes. Now, there is that final point before we go. There's that final point about the Sale of Goods Act and the Queensland legislation. What is the significance there? So as far as the Sale of Goods Act of 1896 of Queensland is concerned, it only has an applicability if the good is a necessity. So in other words, if the good is not a necessity, then that specific statute under Queensland legislation will not apply. Common law principles will apply. And that specific legislation, which is the Sale of Goods Act of 1896, provides that where there is a necessity, and it has been sold and it has been delivered to the minor, then in that case, the minor will have to pay a reasonable price, which in that case is actually consistent with the common law principle. Okay, but the Queensland legislation, the Sale of Goods Act, will have no application if the good that is involved is not a necessity. Okay, I need to go, and if you have any questions, just flick me an email. Questions so far? None? Okay, we've got a class in a minute. So I'll catch up with you again next week. Thank you. Bye.